and welcome to another edition of On the Road with Legal Talk Network. This is Jeewon Kim Serrato, Executive Committee member of the Antitrust, UCL, and Privacy section of the California Lawyers Association. I'm the host for today's episode, which is being recorded on location at the 2019 California Lawyers Association annual meeting in Monterey, California. I'm the U.S. Head of Data Protection, Privacy, and Cybersecurity at Norton Rose Fulbright and partner in our San Francisco office. Joining me now, I have Jose Lopez, Alisa Hall, and Njeri Mutura. Before we get to our topics, please tell us more about yourself. Where do you work and what do you do? Let's start with guest number one, Jose.
Yes, my name is Jose Lopez. I'm a Senior Director of M&A Legal at Samsung Next. Samsung Next is Samsung's innovation center in the Silicon Valley, and I focus on M&A transactions, venture investments, and general corporate compliance.
And Njeri?
Good morning. I'm Njeri Mutura, and I'm a senior corporate attorney at Microsoft. I support the enterprise commercial business in the West region of the United States, sitting out in Southern California. And I deal with transactional matters as it relates to cloud services, AI, and disruptive technologies, and the terms around that. And privacy is very alive and well in my world.
Alisa?
Hi, I'm Alisa Hall. I'm the Director of Privacy and Compliance at eBay, and we're based in San Jose. And I'm responsible for a lot of product counseling related work in the privacy space and also privacy compliance.
Great. And the four of us just spoke on the panel this morning at CLA annual meeting with the topic of data is the new oil, antitrust and privacy issues. And for a lot of the listeners, those two topics might not be the easiest two to put together. Does privacy have any impact on competition? Do we believe that some of the privacy requirements that are coming down the pike, for example, the California Consumer Privacy Act, does that help to level the playing field if data can be made portable so that the smaller companies can have access to the same data to build their products and services? Or does the compliance burden that comes from these new privacy laws actually make it prohibitive for smaller companies or really any companies to enter the market altogether? Jose?
Yeah, I think the way that we're addressing the question, privacy and antitrust, is really unique in the sense that I'm not sure that we have extreme clarity about how those two topics interplay in terms of clear guidelines for practitioners. With GDPR, with the CCPA coming up, we do have a robust body of laws, guidelines, practitioner kind of tips for best practices. I'm not sure that that's the case just yet with respect to anti-competitive behavior and privacy. So, in terms of the implications for competition out of the CCPA, I think there's a little bit of a tension there. I think the data portability component you would think is a very pro-competitive portion of the CCPA. The ability to take your data from one provider to the next would presumably foster competition among those players. I do think it's a little bit of an open question in the sense that we have other examples where portability is available to customers. I'm not sure everybody always uses it. We have the ability, for example, to take our cell phone numbers from mobile carrier to mobile carrier. I personally haven't done that a ton, and I don't think that that's a very prominent feature. I think people tend to be, brand loyal, and so we may find that after this data portability, component is requirement is rolled out, that the brand loyalty and the value, the trust implicit in that customer relationship may be hard to break, even though you're technically able to take your data somewhere else. And on the flip side, where we see requirements and compliance obligations that may, not promote competition, is really the compliance burden in the rest of the CCPA. I think there's a number of requirements that will take significant architecture redesign and compliance, overhauls and, the implementation of not just new privacy policies, but really on the back end, working with, the broader product and company teams to make sure that the CCPA compliance approach is really permeating throughout the company. I think that's something that complexity, the resources required, the experts that you need to bring in, the developers and engineers required to make those changes, I do think that complexity really benefits incumbents. So I'm not sure that we have a clean anti-competition narrative that you could say about the CCPA, because you have on the one hand the data portability that is, in effect promoting competition, but the added compliance burden may prevent smaller players from being able to act and be as prominent in the marketplace in the same way as larger players.
That's a really good point. Alisa, at eBay, let's say hypothetically you have another company that might have a competing product. Hypothetically. How important is this issue for you and for your company? This notion of data ownership, as Jose was saying, if you are the company who's building a product, or if you are the platform builder or maybe a service provider, who really owns that data? Is that the company that's building the product and really kind of putting the R&D behind and improving the product and services? Or is that the end users? Is this an important question for eBay?
Yes, it's definitely a very important question for eBay. I think privacy law and antitrust law would answer that question differently, in my view. I think under privacy laws, consumers ultimately are seen as the owners of the data, because the way that privacy laws tend to work is that they give consumers certain rights to exercise control over the use of their data. And I think from that lens, the consumers are truly seen as the, quote, owners of their data ultimately, whereas I think from an antitrust perspective, it's much more data is viewed as a company asset and is viewed as something that can potentially give companies a competitive advantage or disadvantage, depending on the case, based on the data that they have access to. So I think the question of ownership becomes a little bit complicated when at the intersection of these two laws, where we're seeing that customers have the ability to exercise certain control over the use of their data, but antitrust authorities might want to divest that data and have companies be the ones that demand that companies share that data with others, and that might be counter to what the consumer might ultimately want to have done with their data. So I think those questions are sometimes at odds, not always.
Yeah, I think it's a really good point. So in terms of how this comes to a head, how do these kinds of privacy issues and antitrust issues really kind of become something that the companies really have to grapple with? CCPA has a private right of action that appears to do away with the harm requirement, which we believe is going to lead to more class action litigation. There's going to be more inquiries from private litigants that are trying to basically understand how the companies are collecting and using the data. And so is that privacy litigation that's perhaps going to change the way that companies are perhaps collecting and using the data? Is that going to change behavior? Or is that something more than that? Is there a kind of a push within the company, even outside of the threat of litigation, thinking about privacy as a culture shift, that this is really something that is part and parcel to what you do? And Njeri, I think you were kind of speaking to that in terms of how Microsoft looks at this question.
Yes, definitely. I mean, I think that we've had the conversation about that we've seen the spate of laws. I mean, privacy is definitely alive and it's with us and it's not slowing down. I think there have been a series of, events that have actually made this come to the forefront. When we talk about even before, we talked about Cambridge Analytica or, the various activities in Europe spouted by Max Schrems. Before that, we did have the aspect of government. There was, Eric Snowden, but now it's kind of shifted. Now it's about, privacy in the realm of the company and, in the private space. And, individuals seem to be very aware that, their data is important, that maybe their data might not be used in the manner in which they know about or that they consent. And so even just CCPA, for instance, is something that was was sprouted and it essentially came to light because of an individual wanting to see some difference in that regard. So individuals' consciousness around privacy is something that we're seeing, and for consumers and for customers to be able to trust service providers who have their data, there definitely needs to be a different shift, and Microsoft is recognizing that and has done so for a while. So privacy by design, and I think Alisa mentioned it about, essentially having that throughout the life cycle of the development of your products and your services. And then having just essentially a cultural shift, amongst all the people who are, interfacing with your customers and who are actually handling customer data. So regardless of the regulation, because it started and it's not going to slow down, we see it in California, and we don't think this is the last one that we're going to see at a state level. We expect that we'll at some point see a federal law, and we're hoping that there will be consistency and, guidelines that everybody can follow that, will be essentially helpful as opposed to confusing. But all in all, regardless of the regulation, we're saying it's a best practice. It's good business sense, to think about privacy, to be thinking about, all of the notions of data management. So when we talk about the private law right of action, that definitely is sprouted in, there essentially being some form of a breach. And in addition to that, there's a definition of the exfiltration. So essentially, in order for a company to be sure that they are somewhat safeguarded against, being subject to a private right of action, it's just ensuring that they do have in place the necessary security controls, because of course that is one of the components in order to, safeguard the data in which they're holding and avoid breach. And they also talk about, it's not very clear how that's going to actually be, looked at when they are looking at the private right of action. But if you have taken the necessary measures in your organizations from a security perspective, and of course, in most cases, we're talking about, having the right technology in place to be sure that you're safeguarding, you're encrypting the data, that you have good data management practices. Those are all factors that would likely be taken into account to mitigate, the nature of your exposure when there is a private right of action that comes to you. But essentially, we're saying a mindset shift, a cultural shift, and just privacy being integrated into your day-to-day, because it is good practice, and it will safeguard you when you're faced with all of the different risks with the laws that we have.
And Njeri, you bring up two good points. One is you were talking about kind of GDPR, kind of starting this movement, perhaps EU authorities really kind of pushing the envelope in terms of the Schrems decision, et cetera. And also the second that really whether you have a security breach or not, whether you kind of have the right programs in place to protect the data, that really kind of becomes a mindset shift. If you look at the trend currently in terms of the regulatory fines, clearly in the EU, we have seen some bigger numbers in terms of fines that are coming out of the EU that are related to data breach. But is that interesting? And what do you take away from the fact that the biggest fine so far related to privacy, with regard to the use of data, was not about breach? It was the $5 billion fine by the FTC, which seems to signal that even without malicious actor, without a cyber hack or an actual kind of external penetration of the systems, that the use of data and really kind of a pure privacy question, putting aside security controls, perhaps is the new trend. So I think that's something that I think all privacy practitioners are kind of grappling with, and any companies that hold data are grappling with. And even more than that, it's not just monetary fines anymore. We are seeing from the antitrust regulators that if you have these data monopolies, quote unquote, that they will be investigating whether they need to be broken up. So privacy questions seems to be not just limited to monetary fines and perhaps litigation risk, but perhaps becoming existential questions for companies. That this is, do or die. You gotta get this right, because if you don't get this right, it's gonna have customer loss of trust. That your company could be split up in terms of antitrust issues, and also have very significant monetary penalties.
Mm-hmm. I would say that you're very right. It definitely is an existential question because, and then there seems like even as much as a few years ago, privacy was seen, it's on its own. I mean, I think that it's been a right in California. It's been, something that's recognized, but I think more so now. But the way that it's bleeding into other areas, when you're talking about, antitrust, and you're talking about even in the, talking about just cases of, acquisitions, and people have to look at privacy in all of these different realms. So it's definitely it's taking a it's taking a different head and a different face and complexion that we are having to contend with.
Jose, as M&A counsel, is privacy due diligence more important now than before?
Absolutely. I think if we look at how privacy appears on, our risk profile of target companies, just in the last 7 or 8 years, it's changed dramatically. If we go back to earlier in my career, a couple of privacy questions would appear on a diligence questionnaire. Now we have, typically separate sessions, sometimes for several hours, to try to understand the architecture of a product, of a target that we're interested in. You'll have privacy experts such as yourself come in and advise acquirers and some of the risk profiles associated with how data is collected, processed, stored, transferred. So it's just night and day in terms of how prominent a role it plays in an acquirer's decision-making process. Nobody wants to have, a data breach headline, and nobody wants to have the bad PR associated with having bad privacy practices. And so it's something that executives are much more attuned to, and it plays a much bigger role in the diligence process than it did, even 5 years ago.
Alisa, so as Director of Privacy, what would you recommend for companies that are trying to put all the pieces together? We're thinking about regulatory risk, we're talking about litigation, we're talking about M&A and antitrust considerations. For somebody who is on a day-to-day basis counseling your product teams, what can you do so that you're thinking about this in terms of risk, but also thinking about it in terms of revenue and really kind of having privacy become a competitive advantage?
Yeah, so I think a lot of it requires working not only with the product partners that you work with and the business clients, but also with other lawyers across your legal team to make sure that there's a coordinated approach and an understanding of all of these issues together, and making sure that the guidance that you're providing isn't just from one lens, but is really taking into consideration all of these different, sometimes competing interests, so that it really gives the product and engineering teams and the business folks more clear direction about how they can incorporate all of these different new challenges in the regulatory environment into how they're thinking about developing products and features, and making sure that they're doing that in a way that's compliant not just with privacy laws, but also these antitrust considerations and some other competitive concerns that can come into play. I think it's also important for all of us to just keep up on all of these new developments as they're occurring, because they're occurring very rapidly, and we're really starting to see regulators doing things that are unique and different. Antitrust authorities enforcing data protection laws and the like, which is definitely a new hybrid situation. So just keeping a finger on the pulse of everything that's going on in the external environment there, and always thinking about it with the lens towards how will this impact what we're doing here inside our company, and what are the things that we might need to think about doing differently because of what we're seeing other companies facing in the external landscape.
And in terms of keeping the finger on the pulse, I'm going to plug the California Lawyers Association. We are the state bar for the practitioners in California. And if you want to continue having these conversations, very complex issues in antitrust, UCL, and privacy, our section is starting a privacy working group to think about all things data. We're also going to be looking very closely at the CCPA draft rules, which were issued on October 11th. And so if you're interested in being part of this group to continue to look at data as a valuable asset and the privacy laws that will be regulating how companies regulate, please join us. It looks like we've reached the end of the road for our episode. I want to thank our guests for joining us today. And if our listeners have any questions or wish to follow up, how can they reach you?
I'm at Jose at SamsungNext.com.
Jerry?
Njeri M at Microsoft.com.
Alisa Hall at eBay.com.
And I am Jeewon Kim Serrato. I think there's only one Jeewon Kim Serrato in the world. You can just Google me or Bing me. And thank you to our listeners for tuning in. If you like what you heard, please rate and review us in Apple Podcasts, Google Podcasts, Spotify, or your favorite podcasting app. I'm Jeewon Kim Serrato. Until next time, thank you for listening.
If you'd like more information about what you've heard today, please visit LegalTalkNetwork.com. Subscribe via iTunes and RSS. Find us on Twitter and Facebook, or download our free Legal Talk Network app in Google Play and iTunes. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by, Legal Talk Network, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer.